The Supreme Court will be taking up a gun rights case.
That major decision from the Supreme Court that could shape how federal judges exercise their power moving forward.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
This case could reshape how far states can restrict your right to carry and where.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
In the first few hours of 2026, a century-old federal barrier silently crumbled, instantly making some of the most restricted items in the country more accessible than they have been since the 1930s. While most people were celebrating the new year, a massive legislative shift went live, followed immediately by a judicial earthquake on the West Coast that has left legal experts stunned. These aren't just minor adjustments. We are witnessing a fundamental rewriting of how the Second Amendment is applied in daily life. From the sudden disappearance of federal taxes to a court ruling that just upended the laws in one of the nation's most restrictive states, the landscape of gun ownership has changed more in the last 7 days than in the previous 7 decades. The most immediate shockwave comes from the federal level. As of January 1st, 2026, the long-standing financial wall surrounding the National Firearms Act has been breached. For nearly a century, anyone wanting to own a suppressor, a short-barreled rifle, or a short-barreled shotgun had to pay a $200 federal tax stamp, a fee that, when adjusted for inflation from its 1934 origin, was designed to be a total deterrent. That tax has officially been slashed to $0. Under a new federal reform package, the financial penalty for exercising these specific rights has vanished. It's important to understand the gravity of this. In 1934, $200 was the equivalent of a down payment on a house. It wasn't just a fee, it was a wall. For 92 years, that wall stood firm, creating a two-tiered system where only those with extra disposable income could afford to protect their hearing or own compact rifles. Now, that wall is gone, but here is where the curiosity gap opens. These items haven't been deregulated. You still need to deal with the ATF Form 4, the fingerprints, the photographs, and the months of waiting. Yet, the removal of the tax is already triggering what industry insiders call the year of the suppressor. Demand is expected to skyrocket to levels never seen in American history. We are looking at a future where hearing protection becomes the standard, not the exception. However, there is a hidden catch. The sheer volume of new applications is expected to crush the ATF's processing systems, potentially pushing wait times from months into years. The right is now free, but the clock is ticking faster than ever. While the federal government was dropping the tax, a separate thunderbolt struck the West Coast. On January 2nd, 2026, a 3-judge panel from the Ninth Circuit Court of Appeals delivered a ruling in the case of Baird versus Bonta that has left lawmakers in Sacramento in a state of panic. To understand why this is shocking, you have to realize that the Ninth Circuit has historically been the most reliable ally for restrictive gun laws. But not this time. The court ruled that California's ban on open carry in its most populated counties is flatly unconstitutional. For generations, California has operated under a no-issue or highly restrictive may-issue regime for open carry, effectively making it a crime for millions of citizens to carry a firearm openly for self-defense. The court used a new legal prism, the text and history standard. They looked back to the era of the Founding Fathers and asked a simple question. Was there ever a time in American history where a law-abiding citizen was prohibited from carrying a firearm in public? The answer they found was a resounding no. This decision suggests that if a state makes it difficult or impossible to obtain a concealed carry permit, it cannot then turn around and criminalize the open carrying of a handgun. It creates a massive checkmate scenario for restrictive states. If they ban concealed carry, they must allow open carry. If they ban open carry, they must make concealed carry easily accessible. This ruling doesn't just affect the Golden State. It sends a clear message to New York, New Jersey, and Maryland. The era of the total public ban is officially over. This victory for advocates coincides with a massive and somewhat secretive shift within the federal government itself. A newly created Second Amendment enforcement section has been established within the Department of Justice's Civil Rights Division. Historically, the DOJ has been the primary agency used to enforce gun control. This new section, however, is tasked with the exact opposite. investigating local police departments and state agencies that are accused of slow-walking carry permits or charging unconstitutional fees. They are treating the Second Amendment as a civil right on par with voting or freedom of speech. This means that a local sheriff in a restrictive county who refuses to process permit applications in a timely manner could soon find themselves on the receiving end of a federal civil rights investigation. It is a total reversal of the power dynamic we have seen for the last 30 years, but the most significant battles are still waiting in the wings at the Supreme Court. The 2026 term is shaping up to be a historic reckoning. The first case on the docket is United States versus Hamani. This case addresses a question that has become a legal nightmare in recent years: the rights of marijuana users. As more states legalize cannabis, millions of law-abiding citizens are finding themselves caught in a federal trap. Current law says that if you use a controlled substance, even if it's a legal gummy in your home state, you lose your Second Amendment rights for life. The Supreme Court will decide if the government can permanently strip a constitutional right from someone based on a nonviolent status, especially when that status is legal under state law. The decision will have massive implications for the definition of a law-abiding citizen. Is the Second Amendment reserved only for those who follow every federal regulation, or is it a fundamental right that cannot be taken away without a finding of actual dangerousness? Simultaneously, the court is preparing to hear Woolford versus Lopez, which challenges Hawaii's controversial vampire rule. This is perhaps the most creative attempt by gun control advocates to bypass the Bruin decision. The law declares that almost all private property open to the public, restaurants, shops, gas stations, is a gun-free zone by default. Under this rule, a person with a valid carry permit cannot enter a business unless the owner has explicitly posted a sign saying "Firearms Welcome." It effectively turns the entire state into a sensitive place, making the right to carry practically meaningless. If the Supreme Court strikes this down, it will eliminate the last major loophole that restrictive states are using to prevent public carry. The tension is building because a ruling in favor of the plaintiffs would essentially mandate that the Second Amendment applies everywhere the public is allowed to go. While these high-level legal battles play out, a new reality is taking hold in the individual states. In Illinois, the Safe Gun Storage Act has officially become law, and it is one of the most aggressive in the nation. It doesn't just encourage safe storage, it mandates it with the threat of fines reaching $10,000 and potential jail time if a firearm is accessed by an unauthorized minor or an at-risk individual. This has sparked a fierce debate over the castle doctrine. Proponents argue it's a necessary step to prevent accidental tragedies, while critics argue it infringes on the right to have a firearm ready for use in a home defense situation. This legislative push is driving a massive spike in the sales of biometric safes and rapid access technology as homeowners scramble to comply with the law without sacrificing their ability to defend themselves in the middle of the night. Meanwhile, California is attempting to build a digital wall around the Second Amendment. New transparency laws, specifically AB 1263, now require serial numbers on individual firearm components that were previously unregulated, such as barrels and trigger groups. The state is targeting the ghost gun industry by requiring background checks for the purchase of CNC milling machines and 3D printers if they are marketed for firearm production. It is an attempt to track the untrackable, but with the recent Ninth Circuit rulings, many legal scholars believe these new mandates will be challenged and overturned before the year is out. The state is trying to regulate the technology of the future using the laws of the past, and the collision is creating a legal gray zone for hobbyists and makers across the country. In contrast, the movement for permitless carry is reaching a fever pitch in North Carolina. As of early 2026, the state legislature is pushing a bill that would make it the next state to join the constitutional carry majority. The psychological shift here is profound. For decades, the permit was seen as a necessary compromise. Now, the majority of states have moved toward the idea that a right, which requires a paid permit from the government, is actually just a privilege. If North Carolina flips, it leaves only a small handful of states still requiring licenses for basic carry, further isolating the may-issue strongholds of the Northeast and the West Coast. We also have to look at the sudden focus on common-use hardware. Justice Brett Kavanaugh has signaled that the Supreme Court may finally be ready to address state-level semi-automatic rifle bans. the so-called assault weapon bans in states like Washington and Maryland. The legal threshold is whether these firearms are in common use for lawful purposes. Since there are more AR-15 style rifles in private hands than there are Ford F-150s on the road, the common use argument is becoming nearly impossible for the government to beat. If the Supreme Court takes one of these cases this term, we could see the national collapse of every single rifle ban in the country. The anticipation of this ruling has created a buying fever as citizens in ban-heavy states look to secure their hardware before any potential stays or new legislative hurdles are erected. What we are witnessing in 2026 is the unfolding of the Second Amendment. For decades, the right was treated as a second-class liberty, subject to reasonable restrictions that often felt more like total prohibitions. But the current environment is different. The burden of proof has shifted. It is no longer the citizen who must prove why they need a firearm. It is the government that must prove, through rigorous historical evidence, why they have the authority to restrict it. Every time a $200 tax is removed or a carry ban is overturned or a sensitive place law is challenged, a piece of the old regulatory regime falls away. This volatility creates a unique situation for every gun owner. We are living through a time where the law you follow on Monday might be declared unconstitutional by Friday. Staying informed isn't just a hobby anymore, it's a requirement for staying legal in a rapidly changing environment. The curiosity isn't just about what the law says today, but how those laws will be unrecognizable by this time next year. As the Supreme Court prepares to issue its rulings on marijuana, private property, and semi-automatic rifles, the very definition of American freedom is being recalibrated in real time. We are moving toward a national standard where the Second Amendment is treated with the same weight as the First. The removal of the NFA tax was the opening bell, and the California open carry ruling was the first major blow. The rest of 2026 will be defined by the high-stakes chess match between state legislatures trying to find new loopholes and federal courts determined to close them. Whether you are a longtime enthusiast or someone just starting to explore your rights, the landscape has never been this chaotic, this fast-moving, or this consequential. The rules of the game have changed, and the next few months will determine exactly how far those changes will go. That's it for today, folks. See you in the next video.